apologize, Your Honors. I brought an extra set of thumbs with me today, it seems.
That's okay. Go right ahead. I assume you have already reserved your time for rebuttal, or have you not?
Please, Your Honor, I would.
And what is that time?
5 minutes, Your Honor.
5 minutes for rebuttal. Thank you. You may proceed, sir.
Your Honor, this case arises out of Rome County, and one thing I'd point out is I noticed the docket has Judge Pemberton down, but he recused himself, and this is a decision I'm appealing from Chancellor Williams by interchange.
Go right ahead.
All right. Your Honor, on or about March 1st, 2018, a gentleman named James A. Foist got...
Did you introduce yourself? I'm sorry.
I'm sorry, Your Honor. I'm Tom McFarland from the Rome County Bar. I apologize. On or about that date, Mr. Foist got himself into trouble in Rome County and wound up in the Rome County Jail. Hill Bonding Company responded to his call, and Mr. Foist didn't appear to have any money on him, but he did have the original title to his pickup truck, for which he gave Hill Bonding in return for the money. He took the title, and that title was issued on March 4th, 2016. And what Mr. Foist had done, unbeknownst to Mr. Hill, he had borrowed some money against that truck on at least a couple occasions, and there were applications made for new title. And so eventually he borrowed money from the Appellate, and they applied for a new title. And so one of the questions before the court is which title has precedence over the other. And this was dismissed on summary judgment without considering that. And we submit that's just one of the areas that there is a material fact to be decided by the trial court. And the controlling statute is TCA 53-3-115. And I want to point out that's a conditional statute. It's Section A and Section B. There's two paragraphs in the statute. Section B does not come into play unless the conditions in Section A are met. And Section A reads, in the event any certificate of title is lost, mutilated, or becomes illegible, the owner or a legal representative or successor in interest of the owner of the vehicle for which the same is issued, as shown by the records of the department, shall immediately make application for and obtain a replacement upon the payment of the fee provided in TCA 55-6-101. So the only way the state can issue a replacement title is if they are shown that their original title was lost, mutilated, or becomes illegible. They didn't do that. The state, my argument is, and it's in the record, if you look at every one of these applications, Mr. Foist would go and borrow money, and then the mortgage company, the bank lender, whoever the lender was, would send an application to the state. And on those applications, there's boxes for each one of those there. Lost, mutilated, becomes illegible, and then the person swears underneath it that whichever one of those was the case is true. Every single application that these finance companies and banks gave the state had no box checked on any of the applications, and the state still granted them, which under the statute, they don't have the power to do that. I thought you were asking me a question, Your Honor. I'm sorry. I've got my close-up glasses on. I couldn't really tell.
Go ahead.
So, Your Honor, that's our position. There's issues to decide here, including...
Mr. Farmer, let me ask you a question, because I'm a little confused now. I thought what had happened here was that they took a security interest in the vehicle, and that they submitted the title to the state with their security interest in it, and that the state recorded that or issued a new title that reflected that security interest.
The state issued a new title, but it was on an application that didn't comply with the statute. But when you apply for that title, Your Honor, under the statute, you've got to tell the state it's either lost, mutilated, or becomes illegible. That didn't happen. There's a place on the application where you're supposed to do that, and the signature underneath it swears to which one it was, but the state issued a replacement title when they shouldn't have. So they, in my opinion, they loaned him money on a fraudulent title, because obviously it wasn't lost, mutilated, or destroyed, because he gave it to my client, the original title.
So they didn't send back the title reflecting that security interest?
They did. But they sent a title they didn't have the authority to grant. You know, the statute doesn't say lost, mutilated, or becomes illegible, or just because you send a blank paper up here. That's the only choice the state has to go on. TCA 55-3-115A. Now, if they had presented that properly and told the state it was lost, mutilated, or becomes illegible, well, then paragraph B comes into play and says, upon issuance of any replacement or duplicate certificate of title, the previous certificate that was issued shall be void. But the problem here is the replacement title they issued should be void, because it was either fraudulently or wrongfully obtained, because Mr. Foist couldn't represent that he didn't have the title. He had it in his back pocket. That's what got him out of jail. He had the original title. And again, this was on summary judgment. See, we didn't get to argue these problems in court, that the statute wasn't followed.
I'm interrupting counsel.
I'm sorry, Your Honor.
With reference to a loan, does the lender request a replacement certificate through the state which designates and indicates that there is a security interest held in this collateral?
I think they do. They ask the state to note their security interest on the replacement title.
Note their lien holder status.
Yes.
Is that what happened in these cases with this lender?
That's what happened. That's what happened
So
with this lender.
lender made a request for a replacement title indicating its lien holder status.
Yes, but they didn't say that the title was lost, mutilated, or becomes illegible. That's the only way you can get a replacement title. They should have noted their lien on the original title.
So your client's position is, with reference to any lender who is requesting a replacement certificate of title designating lien holder status, that lender has to make some sort of representation that the original was lost, mutilated, or has become illegible.
That's the only choice that I understand them to have under the statute, Your Honor.
Thank you.
You're welcome. And that's all I would have at this point, Your Honor.
Thank you.
Good afternoon. May it please the court. I'm Matthew Graves from the Knoxville Bar, here on behalf of the Appellate Knoxville TVA Employees Credit Union.
Yes, sir.
This case, as was mentioned, arises out of an action to recover personal property filed by the appellee seeking possession of a 2009 Ford F-150 vehicle that is in the possession of the appellant currently. Appellee is the sole lien holder on this most recently issued title to that vehicle, and they gained that lien holder status by making a loan to Mr. Foist, who is not a party to this action now, but was mentioned by the appellant in his statements. The appellant, as he mentioned, is a bail bondsman and asserts that Mr. Foist pledged the vehicle to him as security for that bail bond. Circuit Court granted summary judgment to the appellee and awarded possession of the vehicle to the appellee, finding that we had a security interest in the vehicle and that interest was superior to any possessory interest of the appellant. And of course, that is what we're here today, is from that ruling. The first issue to address here is that the appellant's brief that has been filed is absent of any citations or reference to the technical record at all. And I raised this within my brief itself. The appellant's brief has therefore failed to comply with the applicable rules of this court, which constitutes a waiver of the issues that have been raised by the appellant within his brief. As a result of this waiver by the appellant, the appeal is without merit, has no reasonable chance of success, and should be dismissed on its own. In addition, the appellant should be assessed sanctions, particularly in the form of attorney's fees and costs that have been incurred by the appellee in this matter. Tennessee Rule of Appellant Procedure, Rule 27A, requires, as this Court's familiar with, requires that the appellant's brief include a statement of the facts, setting forth the facts relevant to the issues presented for review with appropriate references to the record. This rule also requires that within its brief that the appellant must include its argument, and once again, by Rule 27A, with citations to the authorities and appropriate references to the record relied upon. When you take a look at the brief of appellant, he's failed to comply with Rule 27 in his brief. Most notably, there's not a single citation anywhere to the record at all within that brief. There's not any citation or a reference to a page or a location of the technical record anywhere at all. Pursuant to Court of Appeals Rule 6B, this court cannot rely upon any assertion of fact unless the argument contains a reference to the page or pages of the record where the evidence is located, and that this court cannot consider a complaint of the action of the trial court unless there's a similar reference to that page. So with 0 citations to the record, appellant's brief leaves this court with no assertions which you can consider, and no action of the trial court which this court can consider upon appeal. It's not the duty of this court to blindly search through the record and attempt to find the facts and the findings upon which the appellant claims are there or claims to rely upon, and these rules clearly put the obligation of that at the fee of the appellant. Now, the appellant attempts to cure this brief, or its deficient brief, by including a small number of references and citations in its reply brief by adding a small number of purported citations to the record within there. But the requirements of Rule 27A are pretty clear. It states that the brief must contain the appropriate citations, not the reply brief, but the brief itself. And by failing to comply with these obligations, the case law is pretty clear that he has waived these issues on appeal. And I've cited some of those cases for you within my brief. He can't use this reply brief as a vehicle or a method to correct the technical deficiencies contained within the original brief. And I believe this Court of Appeals has held on multiple occasions that an appellant has waived those issues despite attempting to correct them in a subsequent reply brief. And on top of that, such a correction would be fundamentally unfair because, as the appellee, I cannot respond to that reply brief to challenging the deficiencies or inconsistencies or inaccuracies within the citations that he has now asserted within his reply brief. And further, that reply brief does not set forth any factors of good cause which would justify this court suspending those rules. So because of the waiver of all those appeals raised by the appellant, waiver of all the issues raised by the appellant, the appeal should be dismissed, and that the appeal is frivolous, and that we are entitled to an award of damages for attorney's fees. However, even if this court decides to exercise discretion to hear those matters, an analysis under the merits shows that the ruling of the trial court should be affirmed. And in order to properly analyze this claim of the appellant, a brief history of the facts, I think, is necessary. And I think that some of the facts, respectfully, were a little bit in confusion or weren't properly stated by the appellant within his initial statements there. So this case, as I've mentioned, involves a 2009 Ford F-150. It was purchased new in Missouri, and through a series of transfers, it was acquired by Mr. James Foist in 2016. He was issued Title 193 by the state of Tennessee in 2016, And I'll just mention these titles by their last 3 digits because they have a long string of digits within them. So less than 2 months later, it was Mr. Foist that made the application for the duplicate title from the state of Tennessee. It was not any of the lenders. It was not the appellee. It was Mr. Foist that made that application for duplicate title. And the appellant, in his statement of responses to the undisputed material facts that we submitted in this case, acknowledges that matter. That was Mr. Foist that made the application for the duplicate title. So in response to this application by Mr. Foist, the state issued that duplicate title. That was Title 784. And upon issuance of this title, the previous title, the Title 193, was deemed null and void by operation of statute. Foist then used this duplicate title, number 784, to obtain a loan from Homeland Community Bank, and a new title was issued naming Homeland as the lien holder. Later, he refinanced that debt from Homeland that he had to One Main Financial. A new title was issued again that replaced that previous title and named One Main Financial as the lien holder. Finally, Mr. Foist later refinanced his debt with One Main Financial with the appellee Knoxville TVA Employees Credit Union, and that resulted in a new title issued in September of 2017, which is title number 180, and that names appellee as Knoxville TVA Employees Credit Union as the sole lien holder. And once again, in his responses to our statement of undisputed material facts, the appellant admits that this title names appellee as the sole lien holder and that the debt owed by Mr. Foist to us is in default. And also, it's not disputed that this title, the title number 180, is the very last title that's been issued by the state of Tennessee for this vehicle, for the Ford F-150. So it wasn't the finance company or any of these lenders that lost the title or made in the applications under the guise of a lost title under 55-3-115. It was Mr. Foist who made that application, received his duplicate title, and then used that title, that duplicate title, to obtain a loan and then subsequent loans that fell through after that. So I think that the council is a little bit misguided in his statement that it was our responsibility to mark on the application that the title was lost, because we had not lost it. We were simply requesting, turning in the previous title that we had, that we obtained from the previous lender, and requesting a new title reflecting our perfected security interest. It was Mr. Foist who was the one that lost the title at some point in 2016, made the application for that, and received a duplicate title.
So that was the same, in other words, what you're saying is that it was the same title, it was just the same title that reflected your security interest?
So that was a little bit down the road. So Mr. Foist received a title to the vehicle in early 2016, and then when at some point, a couple of months later, he requested that a duplicate title. So then a new title over here was issued that changed that title number to a new title.
And then when he took the loan, you put on there for your security interest, and then sent that title into the state, and they sent you back a new title with the same number on it, but a new number?
New number. So each time that a title gets issued, there is a new number that is issued with that title with each time.
So it didn't go to the state as a lost title, it went to the state as a title reflecting your security interest?
Correct. So once he received that duplicate title over here, as I mentioned, there were a couple of lien holders that were intervening there. So with that last lien holder, which was One Main Financial, we obtained that original title from that lender and sent that back in reflecting our security interests, and then the state issued back a new title with a new number reflecting our security interests at that point. So now, council made a comment that I think was very important earlier, saying that he said they loaned money on a fraudulent title. Well, I think to some extent that's correct, but I think that they in this situation is Mr. Hill, unfortunately. Mr. Hill, as being the bail bondsman, had a title that was taken to him that was already deemed null and void by operation of statute, and loaned money upon it. it's argued that there's no evidence that the Title 193 was lost, but there is. That evidence is virtue of the application that Mr. Foyce made to the state requesting the duplicate title. So one of the appellants trying to ignore the proof that's in the record that application was made there. But then also there's an attempt here to read a condition precedent in the statute that's simply not there. Nowhere in 55.3.115A does it require the applicant to put on any additional proof that the title's been lost or mutilated or illegible. It only has two factors, or only two requirements. It requires the owner to make the application and to pay the required fee, which happened in this situation. It doesn't say you've got to prove it to a certain level. It says you have to do those two things. So that happened, and there's no additional requirements there. And I think appellant tries to read some into there, but doesn't say even what those additional requirements might be. I think we just had this vague argument here that there are some additional requirements there that the state didn't meet. But there's nothing within the statute that describes that. It just has those two requirements that are there: make the application, and then pay the fee. Now, presumably, the state could have, if it wanted to, could have denied that application, but it chose not to in this situation and issued that duplicate title over here. So once that title was issued, 55.3.115B gives that clear guidance, which states that upon the issuance of any replacement or duplicate certificate of title, the previous certificate that was issued shall be void. So I think that's pretty clear that it says once upon issuance of any replacement or duplicative certificate of title. But that clearly happened here, and it's undisputed that happened here. So once that happened, we can't go back and unring and revisit Section A because the state has met the threshold that it feels is there.
In this case, the owner of the vehicle gave the original title to the bonding company for a loan. The bonding company did not make any application with the state to perfect its security interest in the vehicle, simply held the title and the possession of the vehicle. Is that correct? That's
correct. And I think that's very important here is that the appellant has only alleged that it has possession of that title. It's not alleged that it's a lien holder. It's not alleged that it's the current owner of the vehicle. It merely has possession of this title that we don't even know what it says at this point,
Had they attempted to perfect their security interest on that title, they would have been advised that that title was void.
That is our belief. There's nothing in the record that reflects that any application has been made by Mr. Hill to do so. But I think it's our clear belief that application would be rejected because it has been deemed void by statute. And
they issued a new title. They had issued a new title by then. Is that correct?
They had already issued 4 titles. There's been 4 titles that have been issued since his title that he is now claiming that he has superior right to. So to accept this argument of appellant would I believe completely throw the whole title priority system into complete disarray. The statute in 115B there is designed to give finality to the world that the most recently issued title to a vehicle is the valid title. And to accept his argument would allow us to go back and have these ghost titles that are coming back up at indeterminate points in the future and call into question who owns a vehicle and how that they own it. Mr. Hill could have investigated once he received that title from Mr. Foyce. He could have investigated with the state to find out if that was the most recent title. Apparently he did not. Apparently he took Mr. Foyce at his word. But had he called the state or investigated with the state to find that out, he would have found that there have been 4 additional titles that have been issued since that point. So in conclusion, we just ask that this court dismiss the appeal, award cost to us, and if not, to find that we have the superior interest in the vehicle.
Thank you, sir.
Thank you.
Your rebuttal?
Yes, Your Honor. May it please the court, I had asked the court for an extension when this original brief was due because I had COVID at the time. I probably should have asked for another one, but I thought I could do it. When I got their brief, I realized that I had failed to put my citations in the brief, and I attempted to rectify that in my reply brief. So that's what happened. I've probably written 25 or 30 briefs here over my 32-year career, and I apologize for that. But my secretary and my kids tell me that's not the only thing that went over my head during that time period, and whatever the court's ruling is, I want to apologize for that. But I want to point out that the first application by Mr. Foist was not lost. He still had it on him. After that, if I understand it right, the history of the title is in the record, and there was bank officers that applied for it after that. In fact, when TVA applied for theirs, it wasn't signed by anyone. And what this requires you to do is you check whether it was lost, stolen, or mutilated, or whatever the choices you have under the statute. None of it was checked. And then as far as proof goes, you have to sign it under penalty of perjury. What they're relying on is not even signed, much less put on what the reason for asking for the new title is. And this case is bigger than TVA Credit Union and Hill Bonding Company. This case is, can the state keep ignoring the statute? Can we just ignore this and issue titles because somebody sent it up here? And my client did sign the back of the title. I think it's an issue as to whether or not he perfected it like that. I think there's a lot of issues for the court to decide here, a lot of fact questions, and I just want to ask the court to, what they did is they asked the department for the complete history. So it's in the record, the complete history is there. And all these replacement titles were never applied for properly. They were issued wrongly. Mr. Foist probably defrauded somebody, probably defrauded the state. But even the one he signed it under penalty of perjury, but he didn't say he lost it. He didn't say it was mutilated or anything else. That part of the application wasn't filled out. And the lending companies and the Appellate did the same thing. The title they have with their lien noted on it wasn't signed by anyone. We swear to this, it was lost, mutilated, or destroyed. It doesn't say why they're asking for it, and it wasn't sworn to. But the state still issued a replacement title. Thank you for listening to me, Your Honor.
Thank you. I want to thank the attorneys for your presentation. Your case has now been submitted to this court. You should receive our opinion within a reasonable period of time. Thank you both, and the attorneys may be excused. Madam Clerk, will you please recess the court?